Good morning and welcome to the Employment Review. Today we will be covering some of the challenges for managing different types of difficult employees and difficult employee behaviors. While employees are individuals and present unique challenges, we'll address some of the common employee challenges, strategies for handling these challenges, and some general best practices for managing your workforce. My name is Russell Berger, and I am a principal in Offutt Kerman's Labor and Employment Group, and I work with business owners to help them take on the challenges that come with running a business, particularly with respect to employee-related challenges.
Good morning. Like Russell, my name is, I am the Labor and Employment Attorney at Offutt Kerman. My name is April Rancier, and I work with business owners and HR departments to ensure that the workplace is compliant with the relevant employment laws.
So the way we broke this down and where we'd like to begin this morning is with a couple different categories of either problem employees or problem employee behavior. If you're on this webinar, it means that you probably manage employees in one form or another or consult with respect to managing employees. And if you do that, it means that you also deal with passive-aggressive employees or employees exhibiting different forms of passive-aggressive behavior. Typically speaking, the passive-aggressive employee does not confront issues head-on, but instead expresses behaviors that create conflict anyway. This is the type of employee that won't tell you what's bothering him or her, but will give signs that something is bothering him or her. So you might ask yourself, have you ever received an email where you feel like someone was setting you up or guarding or planning against something that might happen in the future? This probably wasn't an accident. And this is something that a passive-aggressive employee or an employee exhibiting passive-aggressive behavior might do. In addition, they might also copy the boss on the email. And it's one of those things where the passive-aggressive employee doesn't want to confront other employees about deadlines or about job responsibilities or about delegating tasks, but will send out an email last minute, maybe copying a boss on it, protecting themselves and potentially exposing other employees to, if not necessarily ridicule, at least set them up to take the fall if something goes wrong. The passive-aggressive employee also will not be a great delegator of assignments, but instead will say things like, do you want to talk about this project? Do you want to figure out how we can handle this thing? And by saying those things, the passive-aggressive employee is setting it up so that other employees end up taking on more responsibility. And so it's one of those situations where the employee will say, hey, someone should solve this problem, and then what they're not saying, but what they're implying is, well, that someone probably shouldn't be me. So this should be someone else's problem. I'm not going to deal with it. One of the other hallmarks of passive-aggressive behavior in the workplace is holding a grudge. And so in this respect, employees that are exhibiting passive-aggressive behavior will remember things that they believe are slights against them, will hold that against people, will be in a position or will keep their eyes open for opportunities to retaliate against their co-employees or their managers. And if the employee has a foothold higher up the chain of management somewhere, will be the kind of employee that will try to skip over the chain of command and get to someone else and bring their problems to them, expecting someone higher up in the organization to solve their problems. So those are some of the hallmarks of a passive-aggressive employee. And what I'd like to talk about now is what do you do? How do you deal with the passive-aggressive employee? And I think one of the primary ways for dealing with an employee exhibiting passive-aggressive behavior is to not fall into that employee's example and instead be specific in terms of describing the problem as you see it as the manager, setting the expectations, or what you expect from the employee, and clearly proposing solutions and a path forward. One of the things that you should be doing as the business owner or the manager is to approach this dispassionately. What you don't want to do is you don't want to get into the emotional back and forth. Um, you don't have to necessarily be a robot. It helps if you are a little bit. And you just want to explain, here's the situation, here's what's going on, here's how we're going to move forward. And I think this is also important, but here's why we're moving forward in this specific way. Because for someone who's exhibiting passive-aggressive tendencies, it's helpful to explain to them the why behind the problem, what problems their behavior creates, because maybe they're not necessarily seeing it, and then why the solution is what it is. I also think that along these same lines, it's also helpful to bring the employee into the problem-solving process. So again, it's a little bit of a unique one-on-one individual situation depending on your skills as the manager and your personality traits as well as the employees. But really what you want to do is you want to be clear, you want to be unemotional, you want to use specific examples, specific facts, highlighting specific consequences and saying, this needs to change, here's why it needs to change, and trying to get the employee to buy into that as you go throughout this process.
Okay, and before we talk about the next common problematic employee that employers often deal with, I just want to mention that we're going to be going through a few of those, like Russell said at the onset of the webinar, and then once we get through those key examples, we will be talking about things that we always urge employers to do that will help companies deal with all of these issues. So there's some standard policies and procedures that every company should be doing that will assist in dealing with any sort of problem that occurs, including these type of personalities. So the next one that we want to talk about are drama queen or kings. I have to make sure I cover both genders there when talking about this, because obviously both men or women are guilty of this sort of problematic trait. So the drama queen or king creates problems in the workplace because it kind of sucks the air out of the room for everyone, and with that goes productivity, which is something that every business owner should be concerned about. These type of individuals tend to be highly sensitive, and because they have a victim-like mentality, everything that you do, whether it's a new policy that's issued or a new procedure that you're asking the employees to adhere to, they're going to scrutinize that and see how it impacts them, and likely they're going to have some sort of problem with that. And I'm sure that as supervisors, managers, business owners, you all have experienced this sort of thing frequently. These type of individuals are also likely to file human resource complaints because they do have that victim mentality. And like I said earlier, it just distracts from the workplace. It distracts the drama queen or king themselves and everyone else who they're venting or talking to. The definition of drama is any obstacle to your peace or prosperity, and prosperity is obviously an important issue here when we're talking about the workplace. And I like the analogy of if you and your team are in a rowboat and you're trying to get to an island that's in the distance, and there's a shark between your rowboat and that island, that shark is the drama. And so you have to figure out how you can deal with those type of employees, because it's not always the answer to rid them from the workplace, because every person at one time or another could exhibit this sort of trait. So it's just how do you deal with it from the onset by implementing certain policies and procedures that we'll talk about at the end of the webinar, and when they present the drama, how you deal with managing that. And some key strategies that we would recommend as specific to this kind of personality is to make sure that that person has their roles and responsibilities clarified. Sometimes the drama can be initiated or amplified because that individual may be insecure about their role within your company. And if you have job duties and descriptions clearly outlined and in written form and updated as necessary, then it could perhaps ease that person's victim-like mentality to think that everyone's out to get them if they know exactly what they're supposed to be doing and how to go about accomplishing their duties. Sometimes you just have to have that difficult conversation, whether it's something that you want your HR representative to handle or a supervisor themselves. Just be frank with that person, let them know that they're taking time away from both their productivity and others by engaging in this sort of venting sessions, and set boundaries. I mean, I think we've all been on the receiving end of this type of person in the workplace, and sometimes it's just best to say, I don't have time to listen to this right now. But as a supervisor, you need to be directing them towards somebody that they can complain to, so that way you could potentially be accused of not seriously considering any complaints that they may have. So it's directing them to the HR or whoever you want to handle those sort of complaints is what you should do, so that way they know anytime something comes up, that's the point person that they should be talking to. And finally, and we'll address this in more detail later, but you need to document any complaints that are given to you as soon as they're made. So as soon as an employee comes to you with some sort of complaint about the workplace, regardless of whether or not it's valid, it should be documented and dealt with in a way in which we'll describe later.
In contrast to the passive-aggressive employee or passive-aggressive employee behavior, we also have what I've termed the aggressive employee. You should have no problem spotting this employee in your workplace, because by definition, this employee, or at least an employee exhibiting this type of behavior, is going to be in your face, direct, and confrontational. This employee has no problem expressing concerns and raising issues, and that, unlike the passive-aggressive employee, is actually the problem here, where everything's a problem, there's a reason why everything is wrong, and this employee will tell you about it as a manager, or tell your mid-level managers about it, and will also tell co-employees about it, which is, in some respects, an even bigger problem, because it can poison the well, or it can get other employees thinking in a way that they wouldn't ordinarily think. So someone exhibiting this aggressive behavior in the workplace is going to appear angry, unable to control emotions, might be directly mean to other employees, might be directly subversive to the goals of the business or management, and is going to present all sorts of challenges to manage. This is the kind of employee that will send an all-caps email to coworkers complaining about something. And April, have you ever got one of those?
Unfortunately, I have.
As a caveat, we deal with lawyers and lawyers on the other side, so we're used to dealing with aggressive people. It's kind of the nature of our job. But in any event, this is the kind of employee that will push back against any instruction. And not that anybody likes being told that they're wrong, but this employee is going to have a particularly adverse and hostile response. And explaining to this employee that they've done something wrong is not going to be as simple, because at every turn they're going to have pushback. There's going to be an excuse, whether it's correct or justified or not. You're going to hear something back from this employee. So how do you deal with the aggressive, in-your-face type? The first thing that I would do, and what I do, frankly, when I'm dealing with aggressive opposing counsel, is pump the brakes. Unless you're an aggressive personality yourself, you're probably not going to be able to out-yell and out-aggressive the aggressive employee. And that shouldn't really be your goal, because being louder doesn't accomplish anything. What you want to do is you want to be right, and you want to influence the employee and persuade the employee to engage in the type of behavior that's constructive in your workplace. So the challenge really is to set expectations without setting a fire. And to do that, and this is somewhat similar to dealing with a passive-aggressive employee, you want to take emotion out of it. because the aggressive employee is running hot, and you want to cool them down so that they'll be more receptive to the facts that you're going to be sharing with them, as opposed to having this conversation from an emotional place. So in that context, while you don't have to out-yell the employee, and you shouldn't try to out-yell the employee, what you should do is you should be firm, and you should be stronger, and you should be more factual. So by that, I mean you confront someone who's fired up, upset that they feel like they've been called out, and doesn't want to hear your coaching, and you speak to them calmly and say, look, I understand your complaints. I hear what you're saying. Let's create a solution. Let's work together on this. Here's what I need you to be doing. Here's how I think you can get there. These are the expectations of the business, and these are inflexible. This is the way it is. You're going to have to deal with it, but say that in a nice way. Say it in a way where you're getting the employee to buy in.
The next type of problematic employee we're going to talk about are social media gurus. This is something that's very difficult for employers to control because, as we all know, social media is used by virtually everyone now, and employees who have access to their smartphones and the computers provided to their employer are going to present issues as to what they can be posting during the workplace, and what you would like them to refrain from posting at any time, whether it's during the workplace or on their own time. So these sort of individuals, they like to post potentially confidential company information, make disparaging comments about their workplace, their salary, other employees, their supervisors, things like that. And what's one of the more concerning ones, in my opinion, are individuals who will purport to make posts on behalf of the company. So maybe it's not a disparaging or a negative post, but they are making a post that they're not authorized to make and are acting as the voice of the company when they shouldn't be. Making what I would call TMI posts about their personal life. So these sort of posts may not implicate the company or have anything to do or reference the company at all, but if they're posting about maybe some illicit activities that they're engaging in on the weekend and also listed as an employee of your organization, that may reflect badly on the company and maybe something that the company wants to address. And then obviously the individuals who allow social media to affect their productivity because they're more interested in perusing social media and making postings than they are in actually doing the work that they're tasked with. So strategies that you can implement to deal with social media gurus. The most important is to have a written social media and computer use policy. However, it's more important than ever to make sure that that policy is compliant. Gone are the days where you can pull off that kind of policy from the internet and keep it around for 10 years because it will likely be not compliant if that's what you do. And the reason for that is that the NLRB, they have really focused on not only social media and computer use policies, but employee handbooks in general. But with respect to the social media policies, they've taken issue with many of the more generic type of social media policies and have actually penalized employers who have used those sort of policies. A good example of that is is something that happened with Chipotle. In March of 2016, so recently, the NLRB determined that Chipotle's social media policy and also the way they implemented it in this one particular scenario that I'll describe was a violation of the National Labor Relations Act. So what happened is they had an hourly employee who saw that the Chipotle communications director had made a comment about it being a snow day in this one particular area. And that hourly employee replied to that tweet and said, well, I had to, and I'm paraphrasing, so I'm not quoting just to make that clear, but he said something along the lines of, well, the hourly employees had to show up to work today despite the weather and, hashtag cheap labor. So obviously that's not a flattering thing for Chipotle to be tagged in on the internet, on Twitter, and to have out there. In a separate instance, that same employee also replied to a customer who had commented something about Chipotle's guacamole, and again, I'm paraphrasing, but the Chipotle employee replied to that tweet saying, well, it's not free like it is at Qdoba, which is one of Chipotle's competitors. Also something that, while it's not about that employee's particular salary or workplace, is probably not something that Chipotle wants out there, where it's saying that they can get something for a better price or free at one of Chipotle's competitors. So what Chipotle did was they said, listen to this employee, that's in violation of our social media policy, which was written, and please delete the tweets and refrain from doing so further. They didn't discipline the employee, and no adverse action was taken against that employee. Despite that, the NLRB, in reviewing the situation and in reviewing the Chipotle's social media policy, determined that the social media policy and Chipotle's actions in asking this employee to delete those tweets and refrain from future similar tweets were all in violation of the NLRA. And the reason for that is that there were several things that they had an issue with Chipotle's social media policy, but one of the things that they had a problem with was that the social media policy prohibited employees from making disparaging comments online, and the NLRB determined that, and the policy also prohibited employees from making false or misleading comments. Well, the NLRB determined that comments were only false and misleading if they were made in some sort of malicious way to hurt the company, and determined that these comments this employee made did not fall under those categories. They also determined that Chipotle's policy that employees couldn't make disparaging comments would create an improper chilling effect on the employee's right to engage in concerted activity under Section 7 of the NLRA. So point being, on the face of Chipotle's social media policy, there's nothing wrong with their policy. It was completely fine. However, because the NLRB is scrutinizing these policies, and in light of this decision and many others that have come down in the past few years, those policies must be much more tailored to the company's specific needs. So you can't just throw in words like confidential information. You need to explain what confidential information is that you're referring to, and it needs to be tailored to protect the company's business interests. So if you have those policies out there, it's really important that you review those in light of these recent NLRB decisions, and make sure that that they're in compliance, because regardless of how you deal with the social media gurus, those can create separate issues for you that you don't want to deal with. But once you have a compliant policy in place, make sure that that's distributed to all employees along with your accompanying handbook, and make sure that if employees are in breach of that compliant social media policy, that they're made aware of that, and follow any disciplinary procedures that you have in place, which should also be in writing, and we'll talk about that in a minute, with respect to any violations of that social media or computer policy.
So we're now at the point in the presentation where we're shifting more into the tools at your disposal that you can use to help manage these various types of difficult employees. And by the way, if you have any questions so far about the different types of employees, or you have any questions about any of the various tools we're going to be talking about here in the next few minutes, feel free to type them in. They'll pop up on our screen, and we'll be able to answer them as we go, and we'll also take some time to answer some questions at the end. But anyway, the first tool at your disposal that I want to talk about is the annual review. And this is an annual review that you can use with any employee, from, as April was discussing, the hourly employee working the line at Chipotle, all the way up to the highest level managers in your business. And these are good useful tools, because if nothing else, if you don't do anything else, you're at least having an annual conversation with the employee about how they're performing, what their areas of strengths are, what their areas of weaknesses are, and where they need to improve, which is really what this webinar is all about, is helping you get the most out of your employees. Now, one of the biggest problems that we see with annual reviews is that the people who are conducting the reviews do not put in enough time. So, you'll see managers evaluating their employees, and it'll be on a 1 to 5 scale for a bunch of different performance tasks, character traits, responsibilities, and the manager will just pick 3s going all the way down, and it's clear that they didn't really put any thought in it. They won't put any comments on at the end, and it really doesn't tell you anything. So to do annual reviews in that fashion, it's not really productive. It doesn't really accomplish anything. It's just kind of a waste of time if you don't actually put in enough time to be serious and thoughtful about it. One of the other points I want to make with respect to annual reviews is that employees should know what's coming. If an employee gets an annual review and the annual review says they're deficient in certain areas, even if you say they're great at 85% of what they do, but there's just this 15% where they're really struggling and they need to improve that part of their performance, if that comes as a surprise to the employee, that means you did a pretty poor job of managing that employee throughout the year. And maybe the employee buried his or her head in the sand and didn't hear what you were saying, but generally speaking, the employee should know, and that's really what we're talking about with all these other flaws that employees have and areas of improvement, is you need to confront these things head on and educate the employee, train the employee, help the employee to become a better employee. And that's not something you can do just in an annual review at the end of the year. You should document it in an annual review at the end of the year. You should track it. You should set performance goals for the next year as part of an annual review that address these things. But in managing employees, you should stay on top of these things. You should make sure that the employee knows these are challenges that the employee has and is working to overcome them. And along those lines, one of the other things that you should be asking yourself in conducting an annual review is, how does this help my business? What am I doing in this annual review that is advancing the cause of my business and making us more profitable, making us run more efficiently, reducing the number of sleepless nights that I have as a manager? And again, one way to do that is to include some future goals and some self-evaluation and from the employee, and that's really all about getting the employee's buy-in. So you have employees that are either passive-aggressive or too aggressive, or dramatist, or or can't keep their mouth shut on social media. Whatever it is, among many other things that employees might do that you might not like. But one of the things that I think is a unifying way to treat any type of challenged employee is to get their buy-in. And so you want to, this is carrot and the stick, this is the carrot, and you want them to see what opportunities are ahead for them, whether it's a raise, a promotion, staying employed, whatever it might be, and you want them to buy into that, and not just buy into that end result goal, but to buy into the process of getting there. So, whatever that might be, depending on that specific employee, those are things that you can accomplish through the annual review.
Okay. So, from time to time, anytime you have a complaint, you're going to have to deal with employee investigations. The way in which your business is going to go about handling those investigations should be determined before any complaint is ever issued. This is something that you want to make sure whoever is going to be conducting the investigation, whether it's an HR person or some other sort of supervisor or manager, is trained in exactly what it is that you want them to do, so that can be applied almost uniformly for every investigation that you have. Some guidelines that should be applied to every single investigation that's done is that the allegations the employee makes should be written down and kept in an investigative file. Any memos taken from employee interviews during the course of that investigation should also be maintained in that file, and they should be preserved as confidentially as possible. You want to commence an investigation as quickly as you can and have the investigation concluded also as quickly as you can. So that way the complaining employee cannot accuse the employer of not taking any sort of necessary remedial action. So once the investigation is complete, and if you decide that some sort of disciplinary action is warranted against the accused employee, then that should be memorialized in a memo, and that whatever the outcome of that investigation is and whatever disciplinary act you're going to take against the accused employee should be kept in that employee's personnel file, which is different from the investigative file that we just talked about. The details of the investigation you want to be kept only in the investigative file and not in any personnel files. And the reason for that is you want to keep those separate in the event that an employee asks to see the personnel file, and that way you can keep those investigative details confidential, which is something that's important to do for obvious reasons. You want to make sure that you are recording what we call the 4 W's, which is who did whatever the employee complaining is alleging, what, when, and where. So basically, just gathering as much facts as possible as you can to determine what actually happened and discern what kind of action might be necessary. You want to have the employee who complained be aware of the conclusion of the investigation as well, so that way they know that all loose ends have been tied up and they don't have to worry that the investigation stalled or perhaps not have taken place at all. And if an employee who you're disciplining is refusing to sign the memo that memorializes whatever disciplinary action you're taking, that potentially could be seen as insubordinate. And Russell, what would you do in that situation? What would you recommend the employer do?
With an insubordinate employee?
Yeah, who refuses to sign. They say, I didn't do that. I completely disagree with that assessment. I had nothing to do with it, and I'm not going to sign that memo. I'm not going to agree to your conclusion.
Well, they don't have to agree to the conclusion. You can't force someone to agree to facts. I feel like that's an alternative facts type of situation. But what you can do is, you're in charge. You run the show. This is your business. This is your company. They're your employee. So whether or not they sign it, it doesn't matter to you. You do what. If the discipline was going to be termination, you're going to terminate them. If the discipline was going to be suspension or putting them on a performance improvement plan or doing something short of termination, then you continue on doing that. I mean, obviously, certain people are just not always going to agree that they did something wrong, and that's a hard thing for a lot of people to agree to. And we talked about it earlier with the aggressive employees; they're probably not going to. But what you can still do is you can build a path forward, and whatever that path is, you proceed with that, and you stay firm and resolute. You don't let them push you around.
All right, very good. The other thing about investigations is we frequently work side by side human resource departments in conducting those investigations and making sure that they're done in the way that would protect the company in the event that a lawsuit or some sort of complaint with a government agency is later brought. And when we don't have when we're not involved at that process and we are confronted with defending a lawsuit on behalf of a company later on, the thing that I find that is the most frustrating to deal with respect to investigations is if things haven't been documented as detailed as they should in that investigative file. So as with most things that we'll talk about today and any day with respect to employment law issues, documentation is crucial. So just make sure that any sort of investigation that you're conducting is thoroughly documented. The next thing that we'll talk about is performance improvement plans. These are usually used after the first few disciplinary actions, however it is that your company is going to proceed, and have memorialized, hopefully in a handbook. It's usually one of the last steps prior to determination. The purpose of these plans is to try again to have the employee be aware of what their responsibilities and where they're lacking in their performance, and what they can do to resolve those issues, whether it be issues related to their specific performance or issues related to how they conduct themselves with employees, with any of, maybe they're one of the 4 employees that we spoke to today, and their drama antics are creating a disturbance in the workplace, and this is the last chance you're giving them to try to correct those behaviors. Whatever the issue is, performance improvement plans need to be written down and firmly and fully explained to the employees, so that way they're aware of what their guideposts are and what they need to achieve and when they need to achieve it. You need to have the employee assign receipts of it, so that way you have a record that they are aware of what it is that they need to be accomplishing and what the potential risk is of them not accomplishing, which is usually termination or some other sort of disciplinary action. And then one of the biggest things is just follow up and make sure that you are following through with what you said that you would do in the performance improvement plan. So if it said that you would reassess within 30 days, make sure you have that reassessment within 30 days. Don't let it fall off even if their performance has improved, because you want to make sure to keep this sort of thing documented, so that way you have it in the personnel file in case any sort of issue arises.
So ordinarily, the way progressive discipline works in most companies is you have verbal warnings, you have write-ups, you get to the performance improvement plan, and then, if need be, you get to termination. And all at the same time you're doing the annual reviews that we talked about earlier. But you don't necessarily have to jump from a performance improvement plan to termination. Instead, there's a document that you can use, and you don't use this necessarily in every case, but there's a document called a last chance agreement. This functions in a similar manner to the performance improvement plan, but with a specific and severe consequence of noncompliance. So really what you're doing with the last chance agreement is saying that your behavior, your performance has been unsatisfactory, and sometimes it's a very discrete reason why, sometimes it's a more generic performance issue, but whatever it is, your performance has been unsatisfactory and we intend to terminate you. However, because we think you can turn it around, we're going to give you a defined opportunity of 30, 60, 90 days, whatever it is, to try to turn this around. And we're going to have a very specific, hopefully, possibly measurable goal for you. And if it's not a measurable thing, then you're still going to have a very clear goal so the employee knows what's expected of him or her. And if you don't achieve this, you're going to be terminated, because we already want to terminate you, but we're just going to give you one last chance. So as I mentioned during the annual review about getting employee buy-in, setting goals for employees, and having something for them to shoot for as being the carrot, the last chance agreement is the stick. If you don't, we already think we can fire you, we think we have every right to fire you, we think we should fire you, and we ordinarily would fire you, but we're going to give you one last chance because we think you might be able to turn it around. And if you can't turn it around in this very specific way, in this clearly defined time frame, then we are going to terminate you. And to be candid about it, the last chance agreement, if someone gets to the point where you're putting them on a last chance agreement, it's not all that likely that the employee is going to be able to turn things around in a relatively short amount of time. You've already done write-ups, you've already done a performance improvement plan, you're now to the last chance agreement. This is kind of a long shot that they're going to turn it around, but there's 2 reasons why you do this. One, if you haven't already done write-ups and a performance improvement plan, you don't already have these issues documented, possibly in annual reviews, then you need to document these things to give the employee a chance before you terminate them. Otherwise, you run the risk of the employee turning around and saying, my performance is great, no one ever told me anything, I was wrong, this must be a pretext for some discriminatory reason for why they're firing me. And secondly, it also gives the employee enough room, enough rope to hang themselves. And if you put it on the employee and say, look, the burden's on you, this is what we need out of you, we're going to give you the resources to obtain this goal, but we need you to do it, and then they don't achieve that goal, while they might not want to take responsibility, it makes it a lot harder for them to point the finger at you, the employer, for doing something harmful for them. You've now bent over backwards and accommodated them. So, one of the things that you would do with this is you just make clear to the employee, this is what we want from you, this is when we want it, and if you don't do it, you're going to be terminated. Which brings us to the next set of slides here, which are severance agreements. As an employer, you're always fighting an uphill battle against employment laws and the inherent biases in the judicial system. Now, and while everything we've been talking about are steps you can take to improve the operations of your business and to mitigate against the risk of difficult employees, sometimes it's just a losing battle, and you're not going to be able to move on with the employee, and you have to terminate the employee. And when you do that, you have the option of entering into a severance agreement, which basically is paying some sum of money to the employee in exchange for, among other things, a release of all claims against you. And this isn't necessarily something you need to do all the time, but this is something that you do when you look at the situation, you analyze the situation, and you decide the best thing that you can do is to buy your peace. So on this slide here, there are several necessities to a severance agreement, and one of the things that I think April and I both probably hear far too often is an employer saying, oh yeah, I paid that guy a severance. And I'll say, okay, well that's great. Then did you get a release? Can I see the document? And the employer says, what? Huh? A release? What's that? I just paid him an extra 2 weeks. And to us, we understand the desire to pay people who have been long-term employees, or just pay. You have some human element to this where you want to provide a little bit of a bridge to employees that you're terminating, and all that makes sense, and we would never tell you not to do that if that's what you want to do. But what we will tell you to do is, if you are going to pay any type of severance to an employee upon the termination of their employment, you should absolutely make sure you get a release of claims. Because if you don't get a release of claims, you could pay them 2 weeks, 4 weeks, 6 weeks, whatever your severance is, and then they can turn around and sue you. And now you've paid them out, you've done the nice thing, you feel like you're a good person for having done that, and then you get sued anyway. So if you're going to do it from a business standpoint, make sure that you get something in return. And that something in return, most importantly, is going to be a release. Now, one of the laws that we deal with a lot is the Fair Labor Standards Act, and that's the federal law that deals with minimum wage and overtime requirements. That law specifically states that unless a court approves a settlement or the Department of Labor approves a settlement, the employee's claims under the FLSA cannot be released. So we can't actually obtain a release of those claims. So what we do is we include language in a severance agreement that says, where the employee says, hey, I've been paid everything that I'm owed, nothing's left to be owed to me, and that doesn't release the claim, but at least gives you a piece of evidence if they ever try to challenge you on it. Some other things that I think are necessities in a severance agreement are there's specific language that needs to be included for an age discrimination release, and that's for employees that are 40 years of age or older. So that's not really all that old, but that's where the age discrimination law kicks in. One of the other things that you want to do, and this obviously is not going to be the case in a lot of situations, but if you have restrictive covenants, if you have non-competes or non-solicitations or confidentiality, non-disclosure type agreements, you want to make sure they're incorporated into the severance agreement, because sometimes you could have a severance that wipes out everything that came before it in terms of an agreement or a contract or a policy. So you want to make sure those things are incorporated into a severance agreement as well. In addition, there's a few other nice to haves. These aren't as critical, but if you think the employee is just going to sign it no matter what you put in there, you would definitely include these things, which would be any additional confidentiality or non-disclosure provisions, confidentiality with respect to the severance agreement itself, non-disparagement, which actually can be a pretty valuable thing, because you don't want a former employee going around to your customers and talking poorly about you, and any additional restrictive covenants. Or if you didn't have a non-compete or a non-solicit during the course of employment, but you want to stick it in at the end, this is one way you can do that as well.
So we've talked about a few different types of documentation that's important to deal with these sort of problematic employees, and we just have them listed here for your reference. There's a few others in here that we didn't specifically talk about today, but when we send a thank you for attending today's webinar, you'll have access to the past webinars that we've done where we've delved into these sort of things in more detail. And obviously, if you have any questions or issues, please feel free to contact us directly.
All right. So if anybody has any additional questions, feel free to submit them now. It's a few coming in. We'll take a look and try to respond to as many of them as we can.
So the question that we have is whether or not we have samples of severance letters. And while we do have certain templates that we can work from so that we're not working from scratch, there are certain requirements depending on what state the employee is working from that you are issuing the severance agreement, and also it's unfortunately can be dependent on the circumstances with respect to that particular employee's termination. So we don't have any that we distribute, but in the event that a client asks us to assist them with that, it's something that can be done very quickly.
Right, yeah. The idea is that these forms are going to be 85–90% the same a lot of the time, but there's going to be certain customization, there's going to be certain issues, and that's if that wasn't the case, you could just go on Google and find all these forms yourself. But we think that you need that customization, and you need some specific guidance a lot of the time.
And you can go out on Google. I mean, to touch on Russell's point earlier, if the agreement's not valid and you pay the severance, they can still come after you anyhow. And I actually had a client in New York who paid something to the tune of $50,000 or $60,000 in severance, and because the agreement that he pulled off wasn't valid because it didn't have the necessary language to release the FLSA claims, that individual was still able to come after him for alleged overtime wages. So it's just something to be mindful of when you are looking at this sort of thing. Okay. Russell, what do we talked a lot about these different types of problematic employees and some common ways to deal with them. And what do you find to be, as attorney who often is dealing with these things after the problem has been handled directly by the company, what do you find is the most common mistake that you see companies making in conducting an investigation, for example?
Well, I think probably the biggest issue that companies and businesses have is that they tend to just rush into things. And one of the things that I think we try to do as lawyers is think about all the bad things that could happen, all the different problems that could arise, and we try to make strategic decisions based on the whole universe of occurrences that could happen, even if they're low probability. What I think sometimes happens, and that's problematic, is that employers will just kind of shoot from the hip, and they'll have this gut reaction, and to some extent, entrepreneurs and business owners are going to be way more like that than we are as lawyers, and so that's to be expected. But I think sometimes you just want to tap the brakes at least a little bit and think through, okay, well, if I respond to this challenge from an employee this way, what effect is it going to have, not just on the legal process, but on my other employees, the way I run my business? Is it going to set me up for problems with other employees because I treated this one person differently? I think those are the types of things where you don't have to temper your response necessarily, but you should think it through all the way before you take a step out and you act in a specific manner.
Okay. We also have several requests coming in for copies of the slides, and we will be sending out a copy of this for your reference when we follow up with you later this afternoon.
All right. Well, I think that just about does it for us. So we'll, as April said, we'll get the slides out to everyone, and if you have any follow-up questions, you can always feel free to reach out to April or me.
Thank you for spending a little bit of your time with us this morning.
Thank you very much.